Lordship,
Yes.
I'd like to mention item number 4.
Just maybe. Maybe. Item number 4.
Item number 4, Lordship.
Hmm.
The matter may be released after 4 weeks. So, senior counsel, he'll be appearing from Guwahati. And I've already taken the consent from the other side.
Okay, you are making a mention from
Petitioner, from petitioner side, A.K. Prakasto, designated senior A.K. Prakasto.
Okay, so
Yes,
item number 4.
yes.
Okay. 493. On the prayer made on behalf of Mr. A.K. Pukhaistam, the counsel for the petitioner, list this matter again after 2 weeks.
No, yeah, 4 weeks. Lordship.
You are just keeping me whole. There is an interim order here.
Okay, 3 weeks then. Then 3 weeks.
Just show me the pen. 4. After 3 weeks.
Much of
3 weeks could get it.
May I please, my lord?
Yes.
My lord, I beg to mention item number 18, my lord.
18.
Hmm.
Can it be on 7th of March?
On the prayer made on behalf of the parties, list this matter again on 7/3/2020.
All right.
My lord, I beg to mention unlisted matter,
Hmm.
bail application.
My lord. My lord, I'd like to mention item number 6 is listed for admission hearing, but I'm the conducting counsel. So my head is item number 6
Huh.
is listed for admission hearing today, but I am the conducting counsel in this case, this matter. So my health is not.
On the prayer made on behalf of Shajab, Islamic Council for the petitioner, list this matter again after 2 weeks.
Interim is there, my lord.
Interim order earlier to continue, also
Definitely.
till the next date of this.
Your Lordship, I'd like to mention item number 27. The learned counsel for the petitioner is out of station on medical ground. So kindly fix the matter.
This prayer on behalf of
Tajum Game. So, his name is actually not reflected in the cause list.
okay on the
Yeah, the matter may be
your name
G. Jumpi.
G. Lumpi, learned counsel appearing for the petitioner in item for the petition item number 27. Finds that the arguing counsel is not available today. And accordingly, the matter may be adjourned and fixed for
After 2 weeks, Your
fixed
Lordship.
after 2 weeks. So this is the matter after 2 weeks on a date to be fixed by the registrar.
Much obliged, Your Honor.
Yeah, Lordship. I beg to mention item number 3, Your Lord. I am both the petitioner, Your Lord.
Hmm.
Actually, the leading counsel is out of station, Your Honor,
Hmm.
due to some domestic problems.
Okay.
The matter may be.
Is the chairman available in the state consumer court?
No, Your Lordship.
Till now not
Not yet.
appointed.
Yes. Yes, Lordship. Matter may be fixed for on 7th of March. Your Lordship.
Any auspicious day?
Yes,
It's
fix
an
it
auspicious day.
Yes, Your Lordship. It's may fixed on
7th
Seven.
of
On the
March.
prayer of the parties, list this matter again on 7/3/2024. There's an interim order.
yes, yes,
Interim
yes.
order passed earlier should continue till the next date of this.
Much
My lord. May I please, my lord? I beg to mention item number 16 on behalf of Mr. Rajesh Sonar.
Hmm.
He is out of station, so the matter may be
On the
posted
prayer made on behalf.
6th of
Mr. R.
March.
Sonar, list this matter again on
6th.
6/3/2020.
Highly request. My lord, another unlisted matter, my lord. I beg to mention, there's a difficulty. This is a criminal petition. What happens is in the last occasion, my lord, in this bench only, it was listed on 23/2/24.
Hmm.
And the next date was given on a Saturday, 2/3/2024. So it being a judicial order, the order is with me. So, it's a
Okay,
Saturday.
That matter,
Yes, it's a Saturday.
sorry. We'll get it, we'll fix it. We'll fix it, you just get it.
My lord.
Again, that Jindal,
My lord. My lord, moreover, my lord, there's another, I'm for the respondent number 2. Another counsel is being there from the client they're appointing, so I have to give the brief also. So can this matter be listed on the second week of March or something?
no, we'll have it on a date because this was not, maybe the other council is also on the, I think I gave a date of 7, but unfortunately it has been reflected as 2.
My lord,
It was to be corrected. It was to be 7, 2 likan, 7 likan.
maybe.
I think the record Mangali will be done. Call for the records. Okay, fine.
Obliged,
Let it come.
My
I
lord,
think it has been corrected as 7th if I'm not wrong. That's it.
my lord.
Yes, madam.
Your Lordship, I'm mentioning item number 20.
Hmm?
Item number 20. On behalf of Senior Counsel B. Oron, Your Honor.
The prayer made on behalf of Mr.
B. Oron.
B.
Oron.
B or
Arun.
respondent.
Yes,
Appearing
sir.
for the respondent.
Your Honor, he is in medical, so matter may be adjourned for today.
No objection?
My lord, in this matter, I am the respondent number 18 to 27, 18 to
Who is
21.
the appellant here?
Present.
No objection? No. Not objected and not objected to by the Direct Council for the appellant. List this matter after 4 weeks on a date to be fixed by the registry. Fine. Anything more?
No.
Yes, Mr. Warwick.
My lord, I beg to mention one unlisted regular bail, only paying for calling CD, my lord.
You have come so far. You
May I
have to
please, my lord?
justify that.
May I please, my lord? My lord, I beg to mention item number 26, my lord. Mr. Khodatama, my senior counsel is out of station. The matter may be fixed on 13th March.
Have you taken the consent of
Yes, ma'am.
Mr. Patil?
Yes, my lord.
You are paying for it?
Respondent number 2. Private respondent.
When do you want it?
My lord, 13th of this month. March,
Okay.
March, yes, ma'am.
Okay.
13.
On the prayer made on behalf of Mr.
K. Tama.
Te Tama, Direct Council appearing for the respondent. List this matter again on 13/3/2024. Deadwood Silo.
Much obliged.
Yes, Mr. Patil.
My lord, I learned this kingdom itself.
What had happened is somehow my brief
Which one?
17, my brief has been misplaced. Just accommodate me for a day.
No.
I prepared the brief, but that my note and the paper book has gone missing from the file. Only for a day, Milord.
Very good.
If it is not inconvenient to your lordship, my lord, can it be taken up tomorrow?
Tomorrow, Friday, because I may have those matters also, other bench matters. May not be. We'll have it on next week, Monday, Tuesday, whenever. 5th. On the prayer made on behalf of Mr. T.T. Tara for an adjournment in the matter today. List this matter on 5/3/2024.
My lord, can we pray for some indulgence? Can this be before this honorable court, court number 2?
That is not mine. I think I think this matter came up before me.
That's why, my lord. Otherwise, it's not a very longest matter.
16 matter. What was the
Dispute is, my lord, since 1991, desperate to have this thing disposed of.
No, what was the issue? What was the grievance?
Land dispute, my
No, what was the?
issue in the sense, he claims that the whole land has been gifted to him. I say I bought a portion of it from,
His father.
yes.
The matter went up to
I
Supreme
know.
Court, came back.
No, it's okay, it's okay.
Only, the plaint was dissect partly. That.
We'll have it 15. Fine.
Fifth man.
Fifth, sorry,
Fifth, yes.
fifth.
Sorry.
Okay. Motion.
Why not? But this is regular well application under port 13 and CRPC.
Yes, Mr. Council, what is that?
Yes, Your Lordship, call for the Your Lordship record.
Do you think it is required?
Your Lordship, in the moreover, the POXO section is there, Your Lordship.
POSCO section, you can't have 397 in every section of POSCO.
It's three, not,
This is 15.
yes, Your Lordship.
Section
How-
15 and
yes.
340, 53.
Yes, Your Lordship. And
What
how,
is the punishment?
however, Your Lordship, on the basing
I
on,
give you a hearing. That's
yeah, yes, Your Lordship, basing on the judgment of this honorable court only, Your Lordship, it's clearly, you'll directly say it in general that in all the POXO matter, it has not,
But
this,
see,
this,
there are Supreme Court matters which says that 397 cannot have an application across the board. You will have to see. What is the punishment? Just to me,
Punishment is only
narcotic
2 years.
NDP. Sorry, POSCO Act.
Section 15 is rupees 10,000. There are two sub-clauses, section 15.
punishment.
And see, another thing. If you read that section 1, is basically they say section 15.
10
Up
years.
to 1 year, up to 1 year.
Okay.
27 small, eh?
He's already behind the bars for 4 years.
No, from clearly it reveals that they were indulging in selling the
No,
narcotics.
come to the charge sheet, page 25. Charges have been framed,
Yes, charges have, charge,
27A only against you.
yes, 27A only. That is
The
an,
main accused has already been allowed to go on bail.
yes. Long back, my lord.
Page 25.
Yes.
In view of the above fact, a prima facie case 22C, 27A against Nanitara, you have already allowed him to go.
Yes.
So and so, so and so. And under section 27A against Kojin, this one. And he is behind bars from 11/1/2020.
Yes, ma'am.
Why didn't you not file an application?
My lord, this is due to the family. Family members wanted to teach him a lesson, so he was.
Your Lordship, it may be typographical mistake because from the fact we have to ascertain what offenses they have.
No, I'm not on that. I'm only on the charge sheet you have filed.
My lord,
The
charge
charge has been framed.
in
The charge framing is there at
page 26.
26. Come to
Yes.
charge framing.
Yes, yes. That is small a.
Small a. Small a means consumption.
They were caught selling in restaurant.
But who prevented you from making that? You could have brought in that. And you have already allowed Nani Tara on bail. There's no point. 4 years he's behind the bars. You have something? Tell me.
If Your Lordship, we call for LCR, then we will ascertain.
I am satisfied. I think this is a fit case. He has 4 times what his maximum punishment would be. Even if he is convicted, no punishment.
Yes.
He'll be released. He's already spent.
My lord, evidence is the prosecution evidence over, and now
Over.
this
313.
trial is at the 313. And I have annexed all the deposition also. None of the witness have stated.
Otherwise, this court is totally against NDPS bill. But this is a fit case. Why should a person be kept behind bars without? We are blocking we are blocking his liberty.
Then Your Lordship
Violated Article 21.
may pass any appropriate order.
Your name?
T Omo.
T. Omo,
Yes, my lord. Tapi Omo.
Tapi, and Mr.
G Tado.
T. Tado.
G Tado.
D. G. Current counsel for the petition. Allowed? Subordinate. Oh, chamber. This vote.
Authorized.
I'll only say that. And say that he will regularly attend the court whenever the dates are.
Yes.
Yes.
Most of it. Huh?
On a similar.
Now, this is, we permitted one only because the whole investigation was in a standstill, right?
Yes, sir.
But that does not mean that in all the accused now will start. Where were you for such a long time? Where were you for such a long time? Why were you not before this court earlier? Nothing.
Your Honor, because,
But, Madam Kanamliki,
Your Honor, if I may be allowed to make my submission.
no submissions. If you want, but this would be the order. We'll fix it on 12/3.
Your Honor, because the other person, the
Other
only
person,
two
we
other
have
persons.
done it with a specific purpose because the CD revealed
Yes, sir.
that the investigations were stalled because that person was not coming in,
Yes, sir.
right? So we permitted him as an interim measure to appear before the police investigating officer, so that the investigation can be taken with this specification that it will be considered on the next day. Now, taking advantage of that, how can you come?
And the,
What prevented you from coming before this court earlier?
that question remains, Your Honor, but this person, since the other applicant has also been allowed by this honorable court, he may also be allowed to appear on the same date.
This court, we will fix the matter on the same day, get your seat.
Yes, your lord.
Ms. Hage appeared, I suppose.
Yes, earlier Miss Hage appeared.
Appeared,
And
and she had produced this case diary.
yes, your lordship.
And
And
therein I saw that from, I think, December, Madam, you had moved. From December, the whole investigation was stalled.
yes,
There
your
was a report that we cannot proceed because we don't get the person, the petitioner,
yes, your lord.
Sange Vangshu, who
Yes.
was the, I think, the middleman. Who was
He's a- he-
considered as the middleman.
Yes, your lord.
Then a method was introduced, so I permitted him to appear, so that the investigation can go forward. And thereafter permitted the IO to submit an updated CD. But that benefit, madam, cannot be given to you.
That is true, Your Honor. But although, because incarceration is only required when the person is
You
not.
people
appearing
have
before-
been absconding. You were not subjecting yourself to that investigating process. Now somebody has got it, so you have come. And that somebody was given not on merits, right? But on a plea that the investigation is not
Proceeding
taken.
further.
So now, let's see on the 12th, if there is nothing,
Yes, sir.
we will see. But Ms. T.Y. Putian, learned counsel for the petitioner, also heard Mr. Spencer, learned counsel, additional public prosecutor, appearing for the state prosecutor. Issue notice, call for the case diary in connection with Rupa PS number 15/2023 under section 20 bracketed C and 25 of the Narcotics NDPS Act 1985. Also, list this matter again on 12/3/2024 along with WPC number AB. Oh, sorry, along with AB, case number AB 26/2024. Right? Yes.
I am playing under section 438 of the CRPC in connection to the Malaysian PS case number 02 of 24, which is under section 341, which is available 397, except 397. All are available sections.
The allegation against you is very serious, Mr. Counsel.
My lord,
Because you say that in the dark,
yes.
you cannot be, you could not have been identified, right? But see, the police had even taken, your allegation is the police had even taken your wife and son to the police station,
Yes,
right?
yes.
We'll have to see.
And
Yes,
Yes,
get to see.
Yes, your lordship.
Will not pass an entrance action.
Okay, your lordship.
Because if this is a norm, you are doing a very great disservice to the society.
actually, I didn't know anything. I was not involved in the
Fine, that the
incident.
CD will say. Then
And
let's produce it.
FIR was also very lately, we tried the loads. Just, I came to know
FIR was lodged in time, but you got the FIR copy lately.
lately.
Fine,
That
we'll
was also,
consider
that was also forced by me only. And I wrote an application.
You have been clearly identified, otherwise the police would not have come and taken your wife and child. Somebody will not, you say you know, you don't know that man till now. I think you have said somewhere that you don't know even that who that man is. So if he has led the police to your house, that means you are identified. Let's see what is there. Your name?
P. Bayer, Sadhu Bayer.
Nadul Bayo, learned counsel for the petition, for the applicant. Also heard Mr. So-and-so for the learned counsel for the additional PP. For the state respondents.
So that maybe, police station, Balijan is very near.
Issue notice, call for the case diary in connection with Balijan PS case number 02/2024 under section 341/39/325/327/427/506 IPC. From list this matter again on when?
7th, your lordship.
7th.
Yes, yes.
We'll try on 7th.
Yes, your lordship. I produced your lordship judgment rendered by this. Your lordship, on para 9, your lordship. Fine. May I read, your lordship?
Just give me a minute. Thank you.
Obliged, your lordship.
Heard Mr. So-and-so learned counsel for the petitioner. Also heard Mr. So-and-so learned counsel, additional people hearing for the state response. This is an application filed under section 439, praying for grant of bail to the accused, Patter type Odia, page 2, Nilani Mahesh. In connection with bail, in connection with ITA Itanagar Women Police Station case number 115 of 23 under section 354 Tamil C IPC read with section 15 of the POSCO Act. Issue notice. Mr. So-and-so appears for the respondent number 1. No formal notice is to be sent. No formal notice is to be sent. However, no formal notice is to be sent. Petitioner to take steps to service of notice upon the victim, respondent number 2, to the officer in charge, Itanagar Women Police Station, routed rooted to the registry of this court. Steps within 2 days, 2 working days. Full stop. On the next date fixed, the London edition PP shall produce the case diary in connection with.
Your Lordship, charge sheet has been filed in this case. Yes, Your Lordship. Call for scan copy of LCR, Your Lordship.
Here only, charge has been framed.
No, Lordship, it fixed on 28 of March. Yes.
Let's see.
Okay.
List this matter again. List this matter again on when? How long will it take for the service to happen?
Service, Your Lordship, at least
2-3 days.
at least 1 week it will take time. Yes, Your Lordship.
We'll have it on 14th.
Yes, Your Lordship. Okay.
List this matter again on 14/3/2024. Registry to put up a note with regard to the status of service upon respondent number 2.
Deeply obliged, Your Lordship.
Number 1. I'll give you this back. I'll just make a note and I'll give it back.
Your Lord, it's okay, Your Lordship. Maybe
Nice.
keep the part of the record, Your Lordship. So you should.
It can be kept.
Yes.
Yes.
Yes, my lord. And I'm for a respondent number 2, my lord, leading counsel is out of station. So last, yes. My lord, leading counsel, his uncle was expired on last week, so he is unable to appear in the court. So matter may be fixed for 5 of this month.
Your body respondent.
Yes, I'm for respondent number 2, private respondent.
You are the informant.
Yes, I informed to petitioner.
No, you are the informant in the
Yes.
present case. Mr. Counsel, you have made allegations against the investigating officer, right? You are there in the case, you know about the case.
No, my leading counsel is.
Okay. On the prayer made on behalf of the Mr. Who is the leading counsel?
T. Tapak.
Mr. T. Tapan. Learned counsel for the respondent. List this matter not objected to by the learned counsel for the petitioner. List this matter again on
5 of this month.
on 5/3/2024.
Then next month.
Why have steps been not taken? Respond number 1 and 2.
Lordship, on record, in the website of the record, it is taken.
But this is the latest note I have.
Service is already completed.
No. 26/9/2023. There is an order of this court.
That is the order of the court, but the
How can I go beyond that?
Lanet court has not perused the website of the
But
record.
even after this order is there. Once an order is passed, you are bound. Otherwise, today I proceed with the matter, they will come and say we have not. This is violated.
Actually, it's the mistake of the, this,
Anybody is appearing, nobody has appeared.
clerk actually.
You file a review. Yes. If there is an order of the court to take re-steps and he has not taken, can I on my own sumoto review that? You cannot.
No, so then I may be allowed to take.
You take steps. Mr. D. Bose.
Yeah.
Learned counsel for the petitioner. Prays that he be given 3 days time, 3 working days time to comply with the directions of this court passed by order dated 26/9/2023 to take fresh steps upon respond number 1 and 2 by registered post with AD as well as by usual NASDIQ process. The petition,
Only respondent number, only one respondent is left.
no,
Another one
respondent
is-
number one's, otherwise it has come.
Yes.
But there is an order here, can't help it. Respond number 1 and 2. You see the order dated 26/9. I've seen that one has come back, but nobody has appeared.
Yeah.
So please take steps again in terms of that. List this matter again after 4 weeks on a date to be fixed by the registry with a note pertaining to the status of service of notice upon the said respondents.
All right.
I don't know why. Yes, Mr. Counsel, what is your view on this?
Your Lordship, the petitioner is not present today, Your Lordship. So for the ends of justice, this matter may be listed after a week or after 2 weeks, Your Lordship.
Respondent.
But can these proceedings be first of this nature in this proceeding?
In my humble understanding, Your Lordship, no. Yes, Your Lordship.
That's my view. Because
There are sufficient
clear-cut
material
case
to
is
proceed.
enough clear-cut case, and this is a case against the society at large.
Yes, Your Lordship.
You are appearing for?
Respondent number 2, I'm sorry.
None appears for the, or none appears for the petition on. However, the learned additional PP, Mr. So-and-so, as well as Mr. For the respond number 2 is present. For the ends of justice, list this matter again on 13/3/2024.
Oblige, Your Lordship.
Number 7. Just a moment. Service is completed. We can have it for admissions.
Yes, service is complete, Your Lordship.
Yes. Say to अपनी लिख लो. So service complete, Madhav, no? List for admissions on 13/3/2020.
Your Lordship, item number 7 and item number 25 is arising out of same FIR. And Your Lordship, the allegation is pertains to commercial
You have got the CD.
commercial quantity. Yes, CD. I have the CD, Your Lordship.
What is that?
Your Lordship, the sufficient material is there, and Your Lordship, the embargo under section 37 they have to overcome.
And see, this is we have overcome 37/1 by hearing. Now you overcome 37/2. Because the way the whole thing is proceeding, this court should be satisfied beyond prima facie satisfaction.
But there is no.
That's the trial it will come. But if we have, you show us, how can we draw a satisfaction?
Yes.
That once we release you, you will not go back to them. Well, it seemed to be an habitual thing.
No, your lordship, not habitual. Actually, my.
See, the quantity.
My
that
name
has
was
been-
wrongly
the
implicated.
Quantity that has been recovered. Now, both of us are before us, you and the owner.
Then I just allow the tenant to use the rent. So
Now,
what?
in your shop, a part was recovered, around 9 kilos,
Yes,
right?
yes.
And then the rest was there,
Resident.
stock in your
Resident.
owner's
Resident.
premises. Tajo,
Yes.
Tapayajo.
Tapayajo, and that is Mushar.
The Musari, yes, Your Lordship. So working under her
I am
direction.
against you. I'll have to dismiss this.
No, Your Honor, at least unless the village accused person, because they are also out of station
Your,
at that time.
Your Lordship,
First day, no? No.
no, Your Lordship, the NDP, Your Lordship, if it is, was the other cases like IPC, then I would have,
It would have been a different
yes,
thing, but
Your
this,
Lordship,
no, sorry.
but the power of the court has been curtailed under section 37 of the NDPS Act, Your Lordship.
37-1, I have heard him. Fine, finished. 37-2. Want an adjournment?
No, Your Honor.
Then you be.
I leave this honorable court.
You're a young counsel, that's why I said, take a chance.
Yes.
You want an adjournment?
Yeah, man.
Want to try it somewhere else?
Yes, sir.
I'll dismiss it. Otherwise.
No, adjournment.
If it was somebody senior, I would not have given this liberty. You try.
Yes.
Try to overcome it. But these are cases wherein that bar, we will have to honor. Item number 7 and
25.
25.
25, who is there?
Same council, Your Lordship.
Oh, you are.
Yes, sir.
Item number 7 or 25. Belik ke likhbo. Eta BA hai, eta AB hai. On the prayer made on behalf of by the council for the applicant, list this matter again on 11/3/2020. But council, if it comes back to me, no more adjournments.
Your Lordship, that
11/3. Any problem, you tell me.
Your Lordship, 11 April or March, Your Lordship?
March.
March, Your Lordship. Your Lordship, since the original CD is with us, Your Lordship, that may be written and again called.
Or you can, we'll have it again on, then let's have it on 4th.
Okay, Your Lordship.
4th or 6th, it will not be problem.
No, no issue. Yeah.
Huh? Fourth
Yes,
or
yes,
sixth?
yeah, 4th or 6th, no issue. Your Lordship.
Let it be on 6th. 6th.
Okay.
But council, if it comes back to me, no arguments. Whatever will be detailed.
Deeply obliged. Your Lordship.
Ideology.
Number 8. Service upon respondent number 3.
Awaited, Your Lordship, yes. Learned Council was present today, Your Lordship.
None appears for the petitioner on call. Office note dated 23/2/24 reveals that the service report on respondent number 3 is still awaited. List this matter again after 2 weeks, along with an updated status with regard to the service of notice upon respondent number 3.
Deeply obliged. Your Lordship.
Number 9.
Meet.
Yes.
Malad, the other day your lordship already heard me on this point, but I'll just like to point out.
Who is there opposing you? Mr.
Well, before my friend starts, Malad, I'll just point out clarification, some clarification. The other day, Malad, I pointed out that the Arunachal Civil Court Act that confers a power of upon the appellate court to decide the appeal or to proceed de novo. But this provision has come up from the original statute, Malad. That is regulation.
Regulations.
If your lordship kindly takes up the regulation Assam Frontier Administration.
Assam Frontier. Mr. Counsel, you went to the village council, as if I understood the facts. You went to the village council. Then there is a dispute. They say on 13th nothing happened. Matter was fixed on 18th.
Yes.
The persons who had gone before the village council, all of them did not go before that larger body. SOPA. All of them did not go. No, all of them did not go. Only a few went before that SOPA. There were more people before the village council, village authority than before the SOPA. Now, when that Parwan was issued to you, you went and filed a written statement. In that written statement, Annexure A is an order dated 13/8 from the village governments. Now, this was contested, taken up. The learned district judge drew a presumption that why should you be before that larger body if you already had an order? But the beauty is, this order of 13/8, rightly or wrongly, was never challenged. Then it draws a conclusion that this order is mandated, it does not exist, so we interfere with that.
True.
And it interferes with everything.
Well,
and then it falls back on the code here and said that now we will go for a trial.
Right.
Now, whether a trial is to be before that court or before a particular court having pecuniary jurisdiction over that, that will be governed by the CPC. It could not have, because of the appeal being filed before it, taken up a case which would otherwise be before a municipal. That's the basic facts here.
Yes. That issue, I'll just.
No, you continue with what you were trying to say. I just wanted to clarify
yes.
the facts.
Not on the facts, Malal, first, that this 13/8, when this order was passed, it was pronounced. And as per the regulation, it requires only pronouncement. The clause 2, which says that the deputy commissioner may have some order. No. Hello.
If you say that 13/8 only a pronouncement is required, when did this 13/8 order come into existence?
On 13/8. 13/8, there was a pronouncement where it was pronounced that I have a right title interest over that plot of land.
I got it.
Madam.
You say
on
a written order is not required.
Not required.
But here, fortunately, we have a written order.
It was a certificate which certifies that there was a pronouncement.
Okay. That certificate is also 13/8.
13/8.
You went up to the larger council when?
On 14/8.
14/8.
14/8.
Now tell me, between 13/8, afternoon, maybe, after this order, you might have had a cup of tea or something, village. What was the necessity of going on 14 to that large council? Because
that is what was categorically pleaded before the district judge
in your affidavit,
in my written objection to the appeal.
Come to that.
Malal will find my written objection, page 41. Para 3, may I just read. On 10/8, a complaint was made by the respondents before the Lees Village Authority that the applicant is encroaching the present suit land. Thereafter, a summons was issued to both the parties by the Lees Village authorities for hearing on 13/8/2021. After receiving the summons, both the parties appeared before the Lees Village Authority, so-and-so Gaubura. In the aforesaid day, the village authority examined the witnesses and taken the statements of both the parties. And after hearing both the parties on 13/8, the village authority had passed an order stating that the land in question belongs to the present respondents. And one of the village authorities, Sering GB, stated that early in the year 2003, the same issue was raised by the applicant father, wherein he was one of the members of the Lees Village Authority.
That's what is there in the certificate.
Yes.
That other reason is
Then, four. That the statement made by the so-and-so, the respondent like to state that after the judgment passed by the village authority declaring title possession in favor of the respondent on 13/8, the respondent went to the aforesaid suit land to make some permanent boundary fencing. The applicant's son, Sri Sangisering, along with some of his friends, came there and tried to threaten the respondent, namely Kamasering and Pasang Darge, and that they will kill the respondent if they make erect fencing on the suit land. Thereafter, the respondent went to the village authority and narrated the incident, but the Lees Village Authority suggested the respondent to approach the Dirang Sopa, which is the head of all the village authorities, which comes under the Dirang Circle. Thereafter, on 14/8, the respondent, namely Kamasering and Pasang Darve, made a complaint stating that after the order passed by the Lees Village Authority, the present applicant has not complied to the decision passed by the Lees Village Authority. Subsequently, the Dirang Sopa had issued Parwana on 26th August 2021 to the applicant to appear before the Dirang Sopa on 29 August 2021. Fine. Now, what was their contention in the appeal, Melo? That when the original court was deciding the issue, it was pending before the original jurisdiction, customary court. The Dirang Sopa did not have this jurisdiction. Now, the appellant, in their appeal, para 4, they have admitted that Dirang Sopa has a jurisdiction over the entire Dirang circle. Now, if your lordship will kindly
That
take.
is with the qualification, last line, an aggrieved villager
Yes.
can straightaway seek redress, address his her complaint before this. village
Without
authority.
resorting to approach before his or our own village authority. Generally,
SOPA takes up
matters connected to two villages or group of villagers of two different villages or sometimes.
To me, what is the status of this SOPA?
No, the status of this SOPA, it is a customary highest court of that community. It has jurisdiction over the entire area.
No, show me from the provisions.
Yes.
Where do you find that? Where do I find that?
The definition of the customary court, that is in Arunachal Civil Court Act 2021. Means.
Is this what you have given me, the latest amended position? Is this the latest amendment? All the amendments are incorporated here. The Arunachal Pradesh Civil Courts Act 2021.
There is a latest amendment which only says that in place of district judge, it will come to the civil judge. That's still the Now the definition, there is no change in the amendment. The customary court, my lord, will find 2D. Means court of traditional council or authority of villages. There's an S, my lord. To indigenous to the state by whatever name called and includes a court of village authority under section 5 of the Assam Frontier Administration Regulation 1945. So to the extent, my lord, that the Dirang Sopa is not a customary court, it's not a dispute before the court. Because both the parties admitted that it had a jurisdiction over the entire Dirang and people can directly.
That is disputed, my lord. I've come to.
My lord, I'm showing it from his appeal memo. My lord. So to that extent, there is no dispute that Dirang Sopa is a body which does not exist in the eye of law. Be that as it may, my lord. Now,
show me what is the customary court.
My lord. I'm sorry, my lord.
What is it? What is a customary court?
The
This customary court here,
my lord,
is in relation to the regulation of 45.
45. Now 45, it refers, the Civil Court Act refers to section 5 of the 45 Act. Section 5, village authorities.
Having a spot.
So true. The deputy commissioner shall appoint such person or person as he considered desirable to the members of a village authority for such village or villages as he may specify and modify or cancel any such order of appointment and may dismiss any person so appointed.
No.
Now,
this village authority is village authority. It can be for one village, it can be for several villages.
Several villages.
But where is the provision that in addition to a village authority, you have another body, an amalgamation of villages?
Well, look, the word which is used in the customary court definition itself, that means a court of traditional council or authorities of villages.
Villages means in section 5, appointed by the deputy commissioner for a particular area. For one village, he can appoint a village authority, or he can appoint a village authority covering several villages.
Several villages.
Fine.
And that is what
here what we have. We have two different village authorities operating. One is the SOPA and the other one is a village authority. Right? Now, show me how this SOPA was appointed.
The para 4 of my written objection at page 44. Page 44. Just your lordship will start from it is to be mentioned here in Miller. In the last of the panel. after the factual part, that subsequently Dirang Sopa has issued Parwana 26 so.
It is to mention.
Yes, Dirang Sopa is the highest village authorities in the most Monpa customary law, which is composition of all villages, which comes under the jurisdiction of Dirang Circle. Moreover, the Dirang administration also recognizes the Dirang Sopa as a village authority and given a panchayat hall to Dirang Sopa to constitute a court. Hence, the Dirang Sopa had the right to constitute any proceeding which comes under the Dirang Circle. It is the oldest judicial system in the Monpa.
Now tell me one thing.
So,
you went there before this SOPA
my lord,
in the year 2021.
my lord.
So by this time, we had all this developments in law taking place. You had the Civil Codes Act coming into being. You had the court set up. Now, how did you go before the SOPA? You came before me by filing this.
Well,
how did you go before the SOPA?
Look, that's what I was trying to. That's what I was trying to start with. That the power that is conferred to a village authority inherently has come from the regulation of 1945, and it prescribes the procedure, the manner how the village authority and the powers what has been conferred to that village authority. My lord, 1945 regulation. Your lordship will come to chapter 4. Starts with regulation 36.
45.
Chapter 4.
Civil proceedings.
Civil proceeding.
36.
My lord. I'll start with regulation 36 first. Civil justice shall be administered by the deputy commissioner, assistant deputy commissioner, and the village authority. So this is the power which is conferred to the village authorities to decide civil cases. Now, if your lordship turn to page the regulation 44. It provides how the hearings are to be conducted. All suits tried by the village authorities shall be decided in an open darbar in presence of parties and at least 3 independent witnesses. Deputy commissioner or an assistant deputy commissioner may direct village authorities to report their proceeding in any case or class of cases in a way which may appear to him to be suitable. Save as required by such direction, no recorded of any proceeding shall be maintained. Only in a case if the deputy commissioner directs. Now, if a party approaches the deputy commissioner and deputy commissioner refers it to the village authority and with a direction that you maintain this record and it has to be placed before the deputy commissioner. Otherwise, no record is required. After hearing both the parties and their witnesses, if any, village authority shall forthwith pronounce a decision. It requires a pronouncement of a decision. Now, this thing...
Does you say that the decision need not be in a writing form, it can be an oral decision?
It can be. The word pronouncement itself says it can be in an oral form also.
Now, tell me...
Now, my lord will kindly find...
One more. Now, this larger body had issued a parwana to him.
Yes.
Is it on record?
Yes. Page 90.
90.
And the place where they were summoned, that itself gives an indication that the authorities recognizes this body.
But It does not say anything about the decision of the earlier body.
No, because, and
you
that they,
come back to the next page. Go to the next page.
next page 91, the
91.
order. Well,
This is the final case settlement by the
Yes.
larger body.
larger body.
No reference here to the 13/8/2021. Why?
It's not there.
Why?
But the issue when it came to the body, the appellate
That
body.
means it's you can have that issue anytime, anywhere you want to have it.
No, like the 13/8 order, it reflects that 2003 also their father raised this issue.
Fine, I got
So
it.
that was the authorities concerned on with their personal knowledge. They have one of the GB member who said that in 2003 also that issue was raised by the father of the respondent. So
But here,
13/8
you
this
had
is
gone
this
up
I don't
before-
find.
You had gone up before this SOPA
Malo,
as per your own admission.
malo,
Because after that, they were also trying to intrude upon your land,
Well.
encroach upon your
Well.
land. So you had gone there.
malo.
So naturally, when you went there, you had disclosed that on 13/8 this was given to me. Why was this not taken into account?
That you cannot have because the order that is passed by the SOPA, my lord, as the court when records the order, my lord, sometimes there are the arguments which are made by the council are not recorded. But it is the decision which has to be seen, my lord, what decision was taken. Now, my lord, what I'm coming into, that as your lordship is exercising 227, my lord will is the impugned judgment, whether that impugned judgment is correct in the eye of law.
No,
Now-
one thing,
My lord,
subject to what he will say.
my lord.
13/8 not being under challenge, could the learned court below try
Could not
to
have.
drawn this presumption? This is just a presumption.
My lord, in fact, if I may say
Comes
so, my
under
lord,
cloud of doubt.
if I may say so, my lord, the appellate court, as the SOPA or the least village authorities, all decisions has come up before the appellate court. Appellate court had the decision, has the power to do it.
To decide.
To decide. And this, my lord, the power of de novo, it has not come just from the Arunachal Pradesh Civil Court Act, my lord. It has come from the regulation 1940.
Show me.
My lord, the 1945 regulation. Your lordship will find
Regulation?
regulation 46. My lord. Any person aggrieved by a decision of a village authorities may appeal to the assistant commissioner in a suit not exceeding 500, to the deputy commissioner in the suit exceeding the that value. Now, all of this deputy commissioner and assistant commissioner, your lordship will read as the district judge because of the amendment. If such an appeal is filed, a record shall be made of the matter in dispute and a decision of the village authority. If the appellate court shall, if necessary, examine the parties, if the decision appears to be just, shall affirm and enforce the decision as its own. And if the appellate court sees grounds to doubt the justice of the decision, it shall try the case de novo and refer it to the panchayat. In any case so referred, the provisions of section 38 shall apply as if the parties had agreed to submit to an arbitration. So, my lord, while deciding the appeal, the regulation has conferred an immense power upon the appellate body to examine the witnesses, examine everyone, and to decide whether the decision of the village authorities were just or not. Matlab, de novo will come later. Matlab. The first part, your lordship, if your lordship can do. Once before the appellate body comes to a decision that the decision of the village council is just or not, before that also the appellate body has a power to examine the witnesses. Now, here is a case, my lord, where the moment the appeal was filed, there were certain allegations leveled by the appellant that the original jurisdiction was in the season of the matter, and the appellate court, the Rang SOPA, they refers it to the appellate court. They said that when the original court, the matter was pending before the original court, the appellate court did not have the jurisdiction. That was
It's
what
not
their
an appellate court, actually.
yes, no, but their contention in the appeal was that. Now we came up before the court and said that no, the original court has already decided. This is the certificate of pronouncement where on 13/8 the matter was decided. So the matter, and this was already decided in 2003, so it was a res judicata. So these were the contentions which were before the court. Now the village authorities were also a party to that appeal. The learned district judge confined its hearing to only both the parties. To come to a just decision whether the contention of the appellant as to that the original suit was pending or that 13(8) was correct or not, the learned district judge had a power to examine everyone.
And if I may have understood you correctly, your case would be if the village councils were village people authorities, that is the respondents number 8 onwards.
8 onwards.
Were heard. Then that respondents also contain the authorities from the village. First one. Who were also
Parties in the Dirang Sabha. So, my lord, now the learned district judge, in my respectful submission, my lord, has exceeded a jurisdiction to hold that the village authority was biased without even hearing them. Because the village authority is a customary code within the definition of that is under the section 2B of the Civil Code. Holding a code to be biased without even examining the entire issue and merely hearing an appeal as it is a revision petition. Second, my lord, the learned district judge was otherwise exercising a power of appeal, my lord. My lord, your lordship knows, my lord, the power of appeal comes from a statute. So the learned district judge was exercising a power of an appellate court under the regulation 1945, read with the Arunachal Pradesh Civil Court Act. So while exercising a power of an appellate court,
follow that system, the
yes,
procedure there.
yes, and that learned district judge cannot give a liberty to the parties to file a fresh plaint. Now, my lord, I'll come to why this fresh plaint is not permissible. Because section 26 of the CPC, it's very clear, my lord. Every suit shall be instituted by the presentation of a plaint or in such manner as may be prescribed. So the definition of institution of a suit means, well, when the plaint is presented, it has to be constituted, it is a fresh suit. Now, moment the appellate court gives the liberty to the parties to file a fresh plaint, and that plaint at that proceeding will be tried by the district judge in a jurisdiction which he is exercising as an appellate jurisdiction, would be a original court. Now, the Arunachal Pradesh Civil Court Act, for a moment, if your lordship takes up once more. My lord will find chapter 2, the classes of civil code of the Act of 2021. In addition to the courts established under any law for the timing in force, there shall be established following classes of civil courts in the state. First is the district judge, court of additional district judge, court of civil judge senior division, court of civil judge junior division. Number E, my lord will find customary court. Now this act, my lord, identifies a customary court to be an original jurisdiction court. So if I understand it correctly, my lord, when the issue was before the customary court, let it assume, my lord, the least village authority, ignoring the SOPA. Then the least village authority is the original court, customary court, from which a appeal will lie before the district judge. And here, my lordship will again now take to the section 15, my lord. An appeal from a decree or order passed by a court of district judge and a court of additional district in original suits and proceeding of civil nature shall, when such appeal are allowed by law, lie to the High Court. Now, when a original suit is decided by a district judge, then the appeal would lie to the before the High Court. Where, because of the fact, my lord, the order 41 says, my lord, the appeal against original decree. So it would be a first appeal before the High Court. Now, if this customary court is constituted to be as the first original court, then the appeal will lie before the district judge, and the second appeal will come before the High Court.
Because that is also part of a civil.
Civil. So this proviso of which confers the power upon the district judge to decide an appeal arising out of the customary court clearly says, my lord, that the district judge may dispose the same or proceed with the case de novo. Now, my lord, this, if we read conjointly with the regulation 46, my lord, we'll have to understand, my lord, that the district judge, while deciding an appeal, has got enough of power to decide the real controversy that of dispute between the parties. So it will not confine to just examine as to whether the decision of the customary court is correct or not.
The 1945 regulations continue subject to this act, right?
Yes. Because there are, my lord, if your lordship takes up Arunachal Civil Court Act, my lord, which I was going through, my lord, the section 27 refers to the amendment that is done in the 1945. And now this amendment deletes all the provisions under the 1945 Act, because these powers are given to the district judge under the Arunachal Pradesh Civil Code.
Gone.
38 gone. This arbitration thing. Then your lordship finds 37 also gone. 39 is also gone.
40 gone.
40 also gone. 40, my lord, it is not gone, it's substituted. The village authority shall try all suits without limit of value. So the village authority, very interesting. Now for a municipal court or civil judge junior division or a civil judge senior division, there are pecuniary jurisdiction fixed by the court. Now for village authorities, earlier there was there is no value, no pecuniary jurisdiction. They can decide any dispute arising between the parties who are indigenous to the state of Arunachal. Now, this 46 also gone, the appeal, because it has come by virtue of section 15 in the Arunachal Pradesh Civil Court Act. 47, 48, 49, 50, 51, 52, 53, 55, 57, 58, all these are deleted. So in my humble submission, my lord, this order of the
now tell me one.
My lord.
As an officer of this.
My lord.
We accept your submission.
My lord.
To the extent that the village authority's decision being right, wrong, not gone into. So far, we are not convinced.
My lord.
We say that is without jurisdiction. But the district court, district judge, while considering the matter, given the power conferred on him under the provisions of the Civil Code Act, ought to have examined the the village authority's decision on its merit.
On its merit.
It was not put to challenge. If he wanted to interfere with it, he should have examined that on its merit. Another way of looking at it, that not being under challenge, that could not have even been touched. The views that he has recorded without examining the private response, the village authorities. You say that is perverse. So if that be so, there will be two ways of this court. We interfere with that session. We interfere with the decision of the SOPA and require the respondent, if he wants, he can challenge the village authorities. One way of looking at it.
Right.
Second way of looking at it, because of the disputes, 13, whether it was there or not there, and the village authorities, they are not before us here. The village authorities are not before us here. Why did you not make them a party? We could have that exercise done here, whether that order was, at least to examine whether that order was passed within the jurisdiction conferred. So we are not conferred here. So we interfere with everything. Remand back the matter to the village authorities, fixing a date for you to appear and have the hearing.
Yeah.
These are the three options available.
Sure.
Yes, Mr. Kanchan.
In fact, if the first option, if your lordship takes up, I think that the district judge, instead of sending it to these village authorities, because some aspersion has been made against these village authorities, not deciding the matter fair. To be fair enough, and the district judge has arrived at a conclusion.
No, that is what I say, that if that be so, the entire decision process, making process, right from the root. back,
It goes VCF.
we
And
should-
then it goes to the lease village authority.
back to the lease.
Lease village authority.
Then you
Or if your lordship interferes with the judgment, because your lordship has seen that the appellate court, the district judge, before it starts the de novo proceeding, also has got a power to examine the witness.
It has not examined.
It has not examined.
So we will not go
So,
into.
so
we will-
now, if your lordship, if we
Because
read,
given the views expressed, without even examining, it had come to a conclusion.
conclusion,
So why, that's a foregone conclusion,
Yes,
what
that's-
it is,
that's-
because of the dispute.
dispute.
And we also say that we have this, there is a gray area that you on the next day moving and that order not seeing the light till you file your written statement.
Written
objection. The order of this, your first village council never saw the light.
Yes.
I have tried to find it out
Yes,
in
yes,
many ways,
true.
but never saw. So
And-
a doubt arises.
Doubt arises. Doubt arises because the moment I bring it in the written statement, that certificate saying that there was a pronouncement on 13A, obviously the appellant could have challenged that if that
He
order
could
would have
he
been
could
there,
have Amended it, he could have.
he
done
could
it,
have amended it.
But he has taken a plea that this is
No, his plea was that the
13A.
13A, there
See,
was nothing.
That issue, now it becomes an issue.
It's become an issue.
Whether on 13/8.
There was a decision or not.
There was a pronouncement
Pronouncement or not.
or not.
No.
So that is an issue which was to be decided.
Yes.
The learned court, district court could have framed an issue on that. And then
Deciding
decide.
that issue,
Could have.
ignoring the judgment of the SOPA.
SOPA, we are not concerned.
Yes.
We are not concerned. But the dispute being with regard to that village authority, we can do one thing. We can impede those people because they were before the appellate court.
So there was a reason for not implementing them in this because,
Why?
well, these people individually or jointly is a customary court matter. It's a
Oh, yeah,
inclusion
the
of a court,
1971 Supreme Court.
Supreme Court. And therefore, so
That's an intelligent way of saying it.
Correct.
That's Mr. Kaushik's capacity. Yes, Mr. Kaushik.
Therefore, my lord, an argument, my lord, before interfering with the 13, decision 13, my lord, no, not hearing to the village authority also goes, my lord.
These are
Village
all-
authority also is a customary court, my lord. Village authority is also customary court, my
He
lord.
accepts that.
No, but then lastly, earlier argument was that he is containing that
You forget his contention.
That-
You tell me your.
Yeah.
Why did you not amend your appeal.
No, my lord,
After the order of 13-8 was brought on, it's perverse, it's totally made out by.
my lord,
That challenge is missing. Why?
for my convenience, my lord, as my lord has asked me to some written argument, my lord, I have prepared it, my lord. I will argue on my written argument, my lord. My lord, now background, my lord, no, my lord.
So I should not be asking anything.
My lord, my lord, I'll
Okay, fine.
for my convenience, my lord. Now, my lord, the past issue, my lord, the contention of the petitioner in this case, my lord, was that this, my lord,
I'll not go into merits.
my lord.
I only want the procedure. This is a revision.
Yes,
Why should I go into the factual matrices?
my lord,
The procedure has been corrected.
my lord. Now, their material contention, my lord, would that, my lord, there was a decision, my lord, 13/8/2020 by the lease authority, my lord, lease place authority, my lord, in their favor, my lord. Now, again, my lord, they saying, my lord, even after this decision, my lord, they goes to the Dirang Sopa, my lord, as the due to non-compliance of the order by the us, my lord. That is their basic content. Now, our contention, my lord, especially we contended before the appellate court, that, my lord. The complaint was lodged by they, my lord, before the lease based authority, my lord. On 13/8, there was no decision, my lord. And next date was fixed on 18/8/2020, my lord. And but they did not turn up, my lord.
That's your case.
My lord. Now, the pendency of this, my lord, lease village authority, my lord, they approached again to the Dirang Sopa, my lord.
Now, is there any pleading on your behalf
My
before
lord.
the appellate court in response to the written statement objection filed by the appellant or the petitioner hearing?
No, my lord.
In the objection, he had brought on record that 13.
My lord.
Did you dispute that before the district court?
Reply, my lord.
Was there any reply?
Report.
Based on the appeal and the written objection, the matter was heard, and they finally did.
Because what has happened is that the authorities, Gamburas, who were included as parties were deleted.
I understand it, my lord. I will try to answer that also, my lord, in absence of our challenge to this, my lord, whether appellate court can interpret. I will try to address it also, my lord. Now, my lord, I find, my lord, the relevant issue, my lord, in this case would be whether any decision was there in the lease place, my lord, before the appellate court, my lord. That other issue would be, my lord, whether the SOPA, my lord, Dirang Sopa, my lord, is recognized under the law, my lord. That is the relevant issue, my lord.
And while you make that submission,
my lord,
paragraph 4, last line,
my lord,
keep that in your mind. Your stand before the tribunal, before the court was that anybody can go there.
Yes, my lord, I do. But
if that is a court not having jurisdiction, nobody can go there under any circumstances.
My lord, my humble submission, my lord, the consent of party, my lord, it is the authority, my lord, of the law, my lord, or jurisdiction of the law is determined by the legislation, my lord. The consent of the party, my lord, would not pass any authority to the, my lord, my lord.
By consent, you cannot give jurisdiction.
Yes, my lord, that's why, my lord. Even if that is there, my lord, that will I try to this, my lord. For my convenience, I will argue my written argument. Now, whether this is, my lord, other relevant issue, my lord, would be, even if, my lord, suppose the Dirang Sopa, my lord, is assumed to have a jurisdiction, my lord, under the law, my lord, then also, my lord, whether it is hit by section 10 of the CPC, my lord, the decision of the Dirang Sopa, my lord, that would the pertaining issue in this case, my lord. Now, fifth issue, my lord, would be, my lord, whether, my lord, in absence of, my lord, in absence of, my lord, certificate being challenged by us, my lord, whether the appellate authority, my lord, can interfere that, my lord. That would the relevant issue, my lord. Now, other would be, my lord, last would be whether Dirang district judge, while directing de novo trial, can direct filing of plain by the party, my lord. That would the relevant issue, my lord. I would start with, my lord, first whether decision, my lord. Now, where I am saying, my lord, there was first issue would be, my lord, whether decision that 13/8/2020 by the lease village authority, my lord. I would say no, my lord. Where, my lord? From the page, my lord, from the record, my lord, it's the record from the district court also, my lord. The proceeding before, my lord, their contention, my lord, that there was a decision, my lord. they did not submit any decision, my lord. Only one certificate, my lord. That is also dated 25/8/2021, my lord. 25, my lord. That a certificate, my lord, enacted by them is, my lord. If my lord see the report, that is not of 13, my lord. 13, my lord. It is dated, my lord. (25/8), my lord. Page number 93, my lord. This is the only certificate, page number 93, my lord, of the appeal revision petition, 93, my lord. This was issued on 25/8/2020, my lord. So I would say, my lord, that there is no decision, my lord. Secondly, my lord, had correctly pointed out, my lord, if suppose there was decision 13/8, my lord, that would be mentioned in the appeal, my lord. Nowhere, my lord, in Parwana, my lord, and nowhere in the decision dated, my lord, by the SOPA, my lord, this is mentioned, my lord. Now, normally, my lord, it is understandable, my lord, if 13/8 decision was in their favor, my lord, nobody will approach under forum, my lord. So the whole this, my lord, presumption goes in my favor, my lord, that there was no decision at all on 13/8/2021, my lord.
Now tell me one thing.
My lord.
When this matter was before the SOPA,
My lord.
the Lish Village Authority Gaumburas were also part of that.
My lord, my lord. Sorry, my lord. My lord.
If this 25/8 was not issued by them, they would have objected. Did they object?
My lord.
Because this SOPA
My lord.
also consists of persons from the village, Lish village.
My lord.
They were there. You went there, you also went there, you submitted your
My lord. No.
motions in response to that Parwana issued to you. Now, if this 25/8/2021 was not correct, forged, whatever it is, they would have objected. Why did they not object?
My lord, that I have taken from, my lord. Why, my lord, that normally, if my lord come to, my lord, they, my lord, village of, I would not make party, but I have made a specific category statement, my lord. Those least village authority were somewhere related to them, my lord. Under the civil act also, my lord, normally, my lord, that is not allowed, my lord. My lord. Now, they was there, my lord. Why, my lord, this village authority also did not, in the decision also, my lord, did not mention, my lord. We already decide, my lord. That is absent in the decision of Dirang Sopo also, my lord. So my humble submission, my lord, those things, my lord, goes against my favor, my lord. As there are no decision, my lord. Otherwise, my lord, person having a degree in their favor, my lord, again approach other forum, my lord. Not believable, my lord. That is my humble submission, the past issue, my lord. That's second issue, my lord, whether, my lord, this decision, my lord, was pending, my lord. Before, when the decision issue was before the Dirang Sopa, my lord, whether any this matter was pending before the list of list village authority, my lord, as no decision was placed on record, my lord, I would say, my lord, that was pending, my lord. Now, third, my lord, whether, my lord, Dirang Sopa, my lord, is recognized under the law, my lord. Assuming, my lord, the Dirang Sopa, my lord, is recognized under law, my lord. To that extent, my lord, already made, there is two decision, there is decision by this honorable court, my lord. Whether, my lord, Dirang, my lord, is a Mumbai dialect, my lord. That means circle and block, my lord. Circle or block, my lord. Now, in our Adi, my lord, normally that is Bango, my lord. Bango. And in Adi also, my lord, like we have a not recognized under this.
The decision, that means the decision of this court,
My lord.
which says Bango is not permissible,
My lord.
will also apply in the case of Dirang.
Sure, my lord.
Bango means circle.
So they said this is immigration of all bills. So they is this Dirang Sopa. There is a specific plea by them that Dirang Sopa is made up of village authority of all the villages under a circle, my lord. That is a categorical plea of that categorical plea, my lord, will find it, my lord.
When is the Parwana issued to him?
The Parwana page 90. 90. It was issued on 26th August 2021.
You had approached that on
14/8.
Yes. Now
Here-
show me that Bango and that.
Their category plea, my lord, at my lord, page number 20,
Your annex the judgment.
Para 7, no, my lord, first, my lord, dear plea, my lord, that this SOPA compromise of all the villages of the circle, my lord. There is specific plea at para, page number 7, my lord, para 4, my lord. Para 4, my page number 7. It is pertinent to mention that Dirang SOPA is the highest village authority in the Mumbai customary law, who is compromised of all the villages which come under the jurisdiction of Dirang Circle, my lord. That already tested by this honorable court, my lord.
Bango, with regard to Adi community, means a
SOPA, my lord.
amalgamation of villages in a
Circle, my lord, SOPA, my lord. So, my lord, my humble submission, I have placed 2 judgment, my lord, that tested by this honorable court, my lord. Now, additionally, my lord, we try to, my lord, put this, my lord, Dirang SOPA under definition of, my lord, this village or civil code act under section 2.
No, tell me which judgment you are relying upon.
The judgment, my lord, I have annexed that is page number, my lord.
Maluk Yongam.
And my lord, yes, my lord. Maluk Yongam and my lord. Ikeriba, my lord. Maluk Yongam is, my lord, 2016 3GLT 344, my lord. Para I have indicated, relevant para would be 7, 8, 9, and 11, my lord, or 10, my lord. 3GLT 344. Here, my lord, likewise in my lord.
What is this DLK means?
District level Keba, my lord.
Huh?
District level, my lord. Beyond circle, there is a district level Keba, my lord. No, now.
Okay, got it.
Page 17, my lord, is my lord. This is my lord. 2 times 21 GLT 8, my lord. So para would be 7 and 8, my lord. Para 7, 8, my lord. 8 would be relevant. In view of the matter, I find that Bango level Kaba would not have assumed jurisdiction to decide the dispute between the petitioner and the respondent. And accordingly, the impin Bango level Kaba decision that is hereby set aside in court, my lord. 7 would be also 7, my lord. And Assam Ponta, a village authority has been recognized as one of the forum for resolving the civil dispute. Apart from village authority, the assistant commissioner, the deputy commissioner, and the high court, there is no other forum determined under the Assam Ponta. Now, my humble submission, but this Dirang SOPA is not recognized, my lord. Normally, we do concede, my lord, in not under the law tradition. We also, my lord, there is a in our also there is a system of Bangalore earlier, my lord. But this is only tested, my lord, by this honorable court, my lord. That is not recognized under the law, my lord. Now, my lord.
So Bango means circle.
Circle, my lord. Circle is SOPA, my lord. That is para. There is their category statement in para 4, my lord.
No, we have got it.
Now, my lord, other aspect of this, my lord, that respondent tried to put this, my lord, Dirang SOPA, my lord, under the definition of this, my lord, D2, my lord, under civil code, my lord, this customary code, my lord. But my lord, will kindly turn to page number 19, my lord. This is subsequent amendment, my lord. The civil code amendment 19, my lord. 19. Annex number C, my lord. This is honest. Now, my lord, my lord, this Dirang SOPA, my lord, does not come under the definition of this customary code under D, because, my lord, is page number 20, my lord. Page number 20, my lord. Page number page number 20, my lord. Page number 20, my lord. This is part of section 3, clause 3, my lord. After the port proviso to the subsection 3 of the section 15, the following subsection shall be inserted. An appeal from the village authority, if agreed by the party, shall be lie before the inter-village territorial customary court or apex customary court, my lord. Now, here, my lord, I am trying to point out, satisfy my lord that this customary court and apex customary court and this inter-village customary court is different thing, my lord. Now, this Dirang SOPA is, my lord, apex customary court.
Trying to argue that there may be a village council, village court. There may be an village court, a circle court, a district court.
My lord.
All this would be a village court, but to approach any other village court other than the village concerned, there has to be a agreement between the parties.
No, my lord. My humble submission of the my lord. Under the law, my lord, 1945, only one village authority is recognized, my lord. Village, for one village, one village authority recognized. Now, if my this is amalgamation of some village, my lord, village council, my lord, that is apex customary court, my lord. If some like Dirang Sopa, wherein so many village my lord, authority come into one forum and decide and give decision, my lord, that will come under the definition of apex customary court, my lord. Inter-village territorial customary court, my lord. Now that has been recognized under this new amendment as a apex court, my lord, appellate court, my lord. Now, therefore, my lord, the earlier C, my lord, this under the C, my lord, section this 19 cannot be this Dirang Sopa, my lord, which is apex customary court, cannot be come under the definition of customary court as provided under section 2C, my lord. Is because, my lord, they now law have recognized them as a appellate court, my lord, separate forum, my lord. If other way, my lord, my argument would be if this Dirang Sopa, my lord, come under the definition of section 2C, my lord, 2C, my lord, it would not, this amendment, my lord, would not have come, my lord. This categorically say inter-village territorial customary court, my lord. I mean, November 20. November 20.
No, you have the 2021 Act.
My lord, my lord.
Come to 15.3.
My lord. My lord.
Have you seen that?
My lord.
We have two provisos there.
My lord.
Right?
My lord.
Now, if you come to page 20.
20, my lord.
No?
My lord.
3.
My lord.
After the fourth proviso to subsection 3.
My lord.
Where are the other two provisos? Where do I get it?
My lord, two proviso would be, my lord.
I think this one, it's brought in by, just above.
So just 3, 1, my lord. Just above, my lord. Just above, my lord. Those are two provision, my lord. Two proviso, my lord.
When is the order of the trial court?
It's the district judge. It is of 31/1/2021. 31st January 2021. Prior to the amendment.
Now that thing has come on record that if he has to transfer, he'll have to transfer to a court considering the pecuniary and territorial.
My lord, I rely on this amendment just to satisfy my lord that earlier, my lord, before this amendment, my lord, no forum, my lord, like inter-village customary court, my lord, like Dirang Sopa was recognized under the law, my lord. It was only the village authority that recognized, my lord. Now, after my lord, this amendment, yes, Dirang Sopa, my lord, like Bango Kaba is also recognized as a appellate court, my lord. To that extent only, I am relying on this, my lord. So, my lord, by this, my lord, I am saying now, my lord.
This is the amendment I was asking you.
That was
got it some other
14 November 2020.
No, it will not have November.
In fact, my lord, this amendment also came because of this confusions. Because in many of the communities, there are a larger body which comprises of all amalgamation of all Gaupura. Like my friend was saying about the Adi.
Bango.
Yes. They still exercise, they have been exercising the jurisdiction of an appellate body as an appellate body, a highest body of that community. So now the amendment of 14 November 2022 clarifies that position, that the amalgamation body would be a highest apex body.
Right.
Now, my lord,
Yes, Mr.
PIP issue, my lord, the whether, my lord, setting aside the passing of certificate dated, my lord, 25, my lord, that village authority, my lord, without same being challenged, my lord, by us, my lord, by the, this is a reason. My lord, I say, my lord, will say, kindly look at order 30, order 40 and rule 33, my lord. Order 41, rule 33, my lord. CPC, my lord, it's CPC, my lord. Page in my case, my lord, 272, my lord.
Order 41 rule?
33, my lord.
Hmm.
Power of Court of Appeal, my lord. The appellate court shall have power to pass any decree or make any order which ought to have been passed or made in to pass or make such order or other decree or order as case may be required, my lord. Now, the explanation of this, my lord, for this, my lord, I am relying on, my lord. This is, my lord, page number 21, my lord, of my written statement, my lord.
That decision.
My lord, this is by Mumbai High Court, my lord, but relying on the apex of judgment, this is beautifully discussed, this, my lord, order 40 and rule 33, my lord. Relevant para would be, my lord, para 8, 12, 13, and 14, my lord. Page number 23, dear my lord, will find it para 8, my lord. Para 8, Sri Sasan's learned counsel for the respondent supported the argument or supported the impugned judgment. According to him, the appellate court acted within its jurisdiction when it granted relief of partition. According to him, the party who relate to each other and will that the assassins have been held to be not improved. Each legal heir was entitled to share in the property. Therefore, no juris who was caused to either party was granting relief of partition. According to him, the appellate court has wide power under provision of order 40 and rule 33 of the court to pass such degree of the case may require, though the respondent may not have filed any appeal or cross objection. He submitted even relief not pray for could be granted by the appellate court in exercise of power in fact and circumstances of the case. He submitted this wide power was vested with the appellate court to enable to do complete justice.
Got it.
Do complete justice.
Got
Now,
anything more?
Now, last issue, my lord. What would, after my lord finding, my lord, there was some injustice, my lord, what would the option, my lord, of the appellate court, my lord, while ordering de novo, my lord, de novo trial? That the last issue I'm addressing, my lord. Now, de novo, my lord, what would be meaning of de novo under this act, my lord? My lord, while interpreting the de novo, my lord will kindly not, my lord, appreciate that this civil court act, my lord, is separate from CPC, my lord. While interpreting this, my lord, we cannot read the provision of CPC like section 26 into this, my lord. Because, my lord, this is independent act, my lord, applicable to Arunachal Pradesh, my lord. This is Arunachal Civil Court act, my lord. Now, I heard, my lord, he while interviewing.
Just one clarification. If this is an appellate,
my lord,
and the appellate powers are exercised by the district court,
my lord,
he cannot dispose of it, the first part.
My lord,
Decides to go
de novo, my lord.
How can he ask you to file a claim?
My lord, that I'm trying to address, my lord. My de novo, my lord. That's why, my lord, the objection is, my lord.
He will have to remain within the confines of that.
My lord.
Any decision on this proviso second part?
No, my lord, no. That's why, my lord. On the last occasion also, my lord, I barely submit, my lord, that this needs some interpretation, my lord.
Because here this or proceed with the case,
no, my lord,
has to be understood in the context which the appeal has arisen.
My lord.
He will go into the shoes of the what do you call that? Least village authority, and then decide.
No, my lord, respectfully, my lord, I'll try to satisfy, that would not be the interpretation. When de novo means, my lord, that should be any, a press, my lord.
NU does not mean that you will be allowed to file a plaint. Once a plaint is filed, CPC will automatically come.
No, my lord, that's why, my lord, I would say humbly submit, my lord, while interpreting this de novo, my lord will not look into CPC, my lord.
Not on that.
My lord.
Once he has asked you to file a plaint,
My lord,
and the suit has been registered as a title suit,
my lord,
this Civil Code Act
My
or
lord.
the regulation does not provide for a procedure how to decide a civil suit.
my lord,
It will be decided by this. CPC will automatically come in.
my lord,
And see, the government understood it.
my lord.
That was understood by the government, and that's why in 22, the amendment has come.
My lord.
And the amendment says it will go before the appropriate court having pecuniary and territorial jurisdiction.
To, my lord,
Satisfy me on that.
my lord, to that extent, my lord, my humble submission, I am also not sure, but I try to, my lord, some rely on this, my lord, say
That's why I
that.
like you. You are very fair.
My lord, kindly see, my lord, pass. I am relying on, my lord, this is my lord, Ajay Kumar Gosal, State of Bihar, pass under 2007 SC 804, my lord, that is a person.
Now, counsel, let's look at it in another way.
My lord.
Now, section 15, that proviso,
My lord.
is in the context of examination under an appellate power, the decision of the customary court.
My lord.
Huh? Right?
My lord.
He can dispose of the same,
My lord.
holding that this is perfect,
My lord.
or upholding or dismissing.
My lord.
Right? Both can be done. Or if he is satisfied, he is not satisfied, like in the present case, that materials are not there. I'll have to consider it afresh.
Amen.
Then (45)(1) is survived. At that point of time, 45(1) was holding the field.
One of the regulation.
44(1).
44(1). Yes,
So tell me-
44(1) survives, 44(2) goes.
44(2) goes, that is in sub, this is by this. And where is that de novo thing here?
46(3).
3. That also gone?
That gone.
That gone.
That gone.
That gone, and this de novo is carried forward in the Civil Code Act.
Civil Code Act. Now, tell me, this de novo,
My lord.
is it in the context of the appeal or the issue? Or a de novo means a total new proceeding?
I prepare in the way of
Then see,
total new, my lord.
This district judge,
My lord.
when he is acting as an appellate authority,
My lord.
he is basically, as a district judge, he is an appellate authority for the customary court. He is not an authority under the CPC. He is not exercising that. Moment he asks you to present a plaint, he is literally asking you to
My
present a
lord.
plaint. Moment he presents you present a plaint, then the provisions of CPC will kick in. 26 will kick in. Jurisdiction will kick in because a forum
My lord.
is taken away. Right? And that now read with that 22 amendment says if there is anything, send it back to the appropriate
My
court having jurisdiction.
My lord.
What is this NU? Can it be said that this case de novo would mean a suit?
Yes, my lord. I try that time.
If it is a suit, it has to go before the court having the pecuniary jurisdiction.
Now that by 210 amendment, my lord, that is that he can, my lord. My lord.
At that time there was no amendment.
My lord. Now, my lord will kindly turn to this is my lord Supreme Court page number 28, my lord. Oh, sorry, my lord. This is
Supreme Court AR 2017-804, my lord. Relevant para out is 14, my lord. Para 14, my lord. Para 14, my lord, will find it, my lord. Oh, sorry, my para 12, my lord. Para 12, my lord, will find it page number 30, my lord, of my written statement, argument. My lord. De novo trial means a new trial ordered by the appellate court in exceptional case when the original court failed to make a determination in a manner dictated by the law. The trial is conduct afresh by court. My lord will kindly note there, as if there has not been a trial in the past instead, my lord. The trial is conduct afresh by the trial as if there has not been a trial in the past instead, my lord. Thereafter, my lord, I would rely next, my lord, on page number, my lord, 34, my lord. 30, but this is page containing the definition
Black
of
law.
tridemo of Black Law Dictionary, my lord. The here also, my lord, the new trial on the inter case that is on both question of fake of issue conducted if, my lord, you kindly note this, conducted if there has not been no trial in the past instant, my lord. Same definition also in my this Abraham
Say,
web
this
system.
last part, proceed with the case de novo, has to be read with the procedure that he will follow. May dispose of this thing.
Now, situation before, my lord, this definition, my lord, by the apex court in the Black Law said that this should be apex, my lord. There should be no.
No,
age-
no means he will not look into the leash village, he will not look into the Dirham.
including the thing before that. It is this is all the record, my
Both
lord.
will go, he will concentrate on the issue, call the parties, take evidence.
My lord.
He can call anybody, or he can direct as an appellate court. He can direct a lower court
My lord, lower court.
to record evidence and then send it back to him. And then take a decision.
My
But even in here, that will again come.
That will not come.
That will not
That will come. Because had this a decree from a lower court to
court,
the
then that
appellate
would
court,
happen.
then to frame an issue, decide the issue.
What is it? Order 42.
Order 41.
41.
My humble submission, my lord. What I understand, my lord, in terms of this definition of de novo, my lord, the apex court in that is Black Law Dictionary, my lord, we can this is all the things should be apex, my lord. Now, if that is so, my lord, the decree by the least business authority, the decree by the Dirang Sopa, my lord, and this all the record of before the appellate court, my lord, where the part, all the record of the appellate court, where the is part of the is the record from the least business authority and the Dirang Sopa, all that need to be go, my lord. Is the this record by the appeal petition, my lord, before the my lord appellate court, my lord, would not be taken in de novo trial because it depends on my lord, de novo trial means afresh, my lord. When that is so, my lord, no, if trial it need to be start de novo, my lord, my humble submission, my lord, there need a plain, my lord. There need a written statement, my lord. There need after that the issue will be framed, my lord. There only evidence. In the absence of those plain, my lord, and evidence, my lord, there cannot be issue, my lord. So my humble submission, my lord, I made especially, my lord. If my lord, lastly, my lord, my humble submission, my lord is exercising jurisdiction at 227, my lord. Now, foremost, my lord will see, my lord, by this impugn order, my lord, any prejudice, my lord. Foremost, my lord, my humble submission, my lord, ultimately, my lord, is some minor error, my lord, like until and there's prejudice to anybody, my lord will not interpret, my lord. So, my lord, my humble, here in this case, my lord, by directing this impugn order, my lord, neither me, neither he, my lord, prejudice, my lord. Ultimately, my lord, this, my lord, if he allow me to file a plain, my lord, I have also no objection, my lord. Let him file, I will file written statement, my lord. But in absence of this situation, my lord, there is no record. If even if he is allowed to file the plain, my lord, as he is the complainant before the least authority, my lord. By this direction, my lord, I was directed to file the plain, my lord, by the appellate court, my lord. Even in my humble,
I'll have to interfere with this.
that is my last submission, my humble submission, my lord. In absence of any,
It would be exceeding my jurisdiction.
my lord. Now,
Revision, right, Mr. Kaushik, can I do that?
in absence of my lord, in absence of my humble submission, not only injustice, my lord, grave injustice, my lord. My lord will surely, this is not a pit case, my lord, to evoke the jurisdiction to
Yes,
my lord.
we have understood you.
My lord.
Just very briefly, my lord. My,
Have you submitted any electronic?
no, my lord, no.
Can you?
I'll do that, my lord. Now, what my friend has said, that CPC application will not come while looking into the de novo thing. The Arunachal Pradesh Civil Code Act Section 18. Application of the code. The code is defined as a civil procedure code in 2C. When I find the application of code. Now, section 2C defines code means code of civil procedure.
Okay.
Yes. The procedure prescribed in the code shall save insofar as is otherwise provided by this act, the procedure followed in all civil code except the customary codes. Now, if your lordship takes up the plaint that is being filed by the respondents pursuant to the judgment of the district judge at page 65. How can it not be treated as a fresh suit? Because this is an application filed under section 9 and 26.
That's what I was trying to elicit.
And moreover, now your lordship will find lordship will kindly take page 23, their appeal memo. Page 23, their memo of appeal. Here your lordship finds who is the appellant. Now my lord will turn to page 66, my lord. The plaintiffs.
It's different.
Plaintiff number 2, 3, they were never before the appellant, they don't have the liberty. Yes. And more so, my lord, I agree what my friend has said. De novo means it's a fresh. Ignoring everything, the decisions which has been taken by the least village authority or SOPA, ignoring everything. These cannot be an influence to decide the issue, the real controversy that is before the. Now, the real controversy which was before the least village authority or the Dirang SOPA, that was with regard to right title interest over the plot of land. The memo of appeal, there is a pleadings where they have claimed that they are the owner of the land. It is the land which they have derived from their ancestors. Now, in my written statement, in my written objection to that memo of appeal, I have denied them. So the issue, the controversy of dispute between the parties is with regard to right title interest. So my humble submission before your lordship would be that this de novo means that the least village authority ought to have decided. As the district judge has come to a conclusion that this decision is not just. And this decision, as there is no record, there is no evidence taken, no record of evidence taken. Therefore, the district judge will exercise his power to decide de novo the issue that ought to have been decided by the least village authority. So that does not require a plaint to be submitted.
That's it. He will have to proceed on his own.
On own.
And not being influenced by CPC, but by the customary law.
By the customary law.
He'll call witnesses whomever he wants to.
Because, and there is a purpose for saying this, section 18, my lord. Not except in cases of customary law. Because in Arunachal Pradesh, my lord.
No. That again, there is a problem. It says customary courts.
Customary courts.
So district judge,
while proceeding de novo, asserts the jurisdiction of a customary court.
Okay.
Because he nullifies everything. And while exercising his power as an appellate court, he becomes the original court to decide it.
Let's see under what provision the appeal was filed.
The appeal was filed Order 41, Rule 1 and Section 15 proviso of the Arunachal Pradesh Civil Code. And Joe, my lord, Section 46 has gone. Which?
No, there's another.
My lord.
Come to order 41.
My lord. The memo of appeal is order 41 rule 1, which mainly says about the form of the appeal, how the memorandum of appeal will be.
Now, even if we just on this form, I understand, maybe
Right.
it's not relevant. Now, if this is a proceeding under 41, and that's a civil court, the customary court is also a civil court. The matter comes up.
It would be a
says-
first appellate court.
It says all bad, everything bad, all set aside. Now, if a de novo is to be, it has to go back to the.
To the least village authority.
Okay, when can you file your written arguments?
Monday.
Monday?
Monday.
लिखिए मैडम. But Mr. B. Kaushik, learned counsel for the petitioner, also heard Mr. L. Premi, learned counsel for the respondents. Let's this matter again. You need not come, you can.
Well, I'll my friend will.
Let's this matter again on 4/3/2024 as a parted matter. Enabling Mr. Kaushik to bring on record his written arguments. Thereafter,
My lord.
Obvious, man.
interesting.
Grateful, man. Interesting.
But please cover up these points.
My lord, I'll.
Yes,
Yeah, Lordship, I'm appearing on behalf of Mr. Omo, the leading counsel for the respondent number 2 to 5. My lord, he's out of station, so matter may be adjourned for today.
on the prayer made on behalf of Mr.
O Modi.
O. Modi, learned counsel appearing for respondents number
2 to 5.
2 to 5.
Your Honor.
And not,
I'm appearing for respondent number 4.
not objected to by the learned counsel for the appellate. List this matters again after
3 weeks, my lord.
3 weeks on a date to be fixed by the ministry. Mr. S. Time. Time.
Yes, Your Honor.
S. Time, learned counsel for the respondent number 4 has entered appearance. He is present. He's
Deeply obliged.
May it please, your lordship. My lord, this is an appeal against rejection of the injunction, my lord, order. My
How
lord,
can an appeal be? You go there.
there is an appeal, provision of appeal, order 43, rule 1R, my lord. After
Rejection of? a
Injunction, rejection of.
Okay, okay.
To be precise, my lord,
Yes, you're ready?
No, Lordship, I'm not ready today.
When?
Not ready.
Where are you sitting now?
Lordship,
You should tell me. What is your problem?
Lordship, we need to file affidavit, Lordship.
my lord, kindly peruse the last order, my lord.
You had entered appearance way back in June
Yes, Lordship.
and you were permitted on 19/2 by me before 27/2.
Yes, actually on last occasion, Lordship, the council who was appeared before this court was instructed to make a prayer that let it be fixed on 7th of March, as the respondent has performed some rituals due to which he cannot come here to sign the affidavit.
Perform some rituals in connection with?
well-being of the house.
Okay, fine.
That's
With
what,
regard to
yeah,
this.
yeah. Therefore, on that day, he could not apprise the court about that matter. So my humble prayer, my prayer would be, Lordship,
We will adjourn it, but cost. How much will you give?
In fact, I may. say
Lordship,
one thing.
last,
This is an
challenge.
appeal, my lord, where the affidavit is no more not required.
Appeal.
But only affidavit which my friend may file on the injunction application along with the connected appeal, my lord. My lord, on the other day also, I made it very clear, my lord, that I am not pressing for this injunction application. Because the issue which has fallen before your lordship is that the injunction was refused on the ground that the civil court do not have this jurisdiction in view of that 2003 Act. But
That
my
is the
contention,
Arunachal Pradesh Eviction of
Eviction Act 2003 Act. My contention was that no, the civil court is wrong. That bar exclusion of civil court jurisdiction cannot be brought
That's
in
why
a
we
section
told
6.
you that this is a proceeding to determine whether notice should be given to you or to him. Notice will come, but to
Notice
him-
will come.
to
And
him or you.
yes, and the my suit before the civil court was section 6 of specific relief act.
You said
Where
you were there, he
he
evicted.
disposes me. So because of that illegal disposition, I have come before the court for a restoration. Now my
Specific relief.
yes, and my restoration in that the government land would not confer any right upon me that I can contest against the government.
They have not initiated any proceedings till now under the
Not
public
against
premises.
not against me,
Against
but
him.
against them there were some proceeding initiated.
Nothing has been taken. to
Nothing has been
Yes.
taken, and the act provides a remedy that if there are orders passed under section 5, 6, 7, 8, and 9,
District judge.
then there is a provision for appeal. Now here is the case, government has not taken any action against me. And section 5, the estate officer has to come up to an opinion that I am an unauthorized document and some action has to be taken against me.
Not against you, the person who is there. in the-
Who is there? Now the exclusion clause in that act itself very clearly says that any action that is taken under this act cannot be challenged in a civil court.
Civil court.
So this is not an here in the civil court we have not assailed any action that has been taken by the estate officer.
That's the understanding.
And therefore, as the civil court, my lord, holding that the civil court would not have this jurisdiction and therefore we are not granting any injunction. So necessarily, what I am before your lordship is that your lordship will have to just decide whether the civil court would have jurisdiction or not. If
We
your
only
lordship
have to say whether that in view of proceedings under the Estate Public Premises Eviction Act, whether this court, whether the proceeding here would be maintained.
Mine.
Your contention would be that we are not concerned with the public premises eviction proceedings. You are concerned with the possession of the land,
Yes,
which you say you had been disposed by.
I have been disposed of. And in fact, my lord, the Act of 2003 does not give any remedy to me for coming before the authority for that illegal disposition. My lord, in fact, the full bench judgment of our High Court, Daulatram Lakhani or Dhulabhai of Supreme Court, which examines the jurisdiction of the civil court, clearly says even if there is an exclusion clause, suppose there is an exclusion clause, but if that act does not provide any remedy, what otherwise the civil court will have, then that exclusion clause will not come. And
You
therefore,
have made out, build up a case that my case is not with regard to that Public Premises Eviction Act,
exactly.
but it's with regard to the possession of the land.
I brought in certain documents, the so-called notices which was issued to them by the estate officer, just to project that, look, I was in possession. When the estate officer came to find out that this person, he was trying to illegally occupy my land, some so-called notice was issued to him. Now, as the estate officer did not...
Are you a permissive position?
No. I was in a position where my name has been recommended for settlement.
Okay.
So, here your lordship, if...
Next week,
Yes, Lordship.
you can come.
7th of March,
17th.
7th of
March. On the prayer made on behalf of Mr. Omud.
Yes, sir.
Yes.
Yes, sir.
Council for the response. List this matter again on 7/3/2024. Mr. P. Kaushik, Learned Counsel for the appellant is present.
Lordship, I may be allowed to file affidavit also.
Well, if
I
they
may
want
be-
to file their affidavit, let them
But,
file their. before.
Given the given the issue arising in the present proceedings, if by the next day, no pleadings are brought on record by the respondent, no further opportunity will be granted for filing any pleading, and the matter would be proceeded with the material. Proceeded with the materials available. None appears for the appellant on call. Ms. T. Jenny Learned, public prosecutor, additional public prosecutor is present. For the ends of justice, list the matter again after 2 weeks. That's it. Huh? On the next day, if no one is there, we'll appoint
A new.
amicus curiae.
Lordship, on the last occasion, this court was, had a question with regard to the maintainability, if framing of charge is an interlocutory order or not. I have a judgment to that effect, Your Lordship. The full bench, at paragraph 15, Your Lordship will see. The second last page. Your Lordship.
Citation number.
Citation number.
Yeah. 2021. SC 2351. Name of the party.
Then.
So,
Neither
Lordship,
interlocutory or
it's need, yes, it's an intermittent.
intermittent.
Yes, Your Lordship, and therefore, it does not bar.
397.
Yes, so the application is maintainable, Your Lordship. However, in this application, the respondent has not been made a party, Your Lordship.
Where is the informant here?
He has not been made a party, Your Lordship.
Yes.
My lord, I've just overlooked the thing. I was on the opinion that it was only on the legal provision.
That madam has clarified.
My lord, my lord, I may be allowed to rectify the page. I may be allowed to implement.
You know, you'll have to file an application.
Oh, obliged.
You
I'll
can't
do
do
it.
it here.
I'll do it.
On the prayer of this, Mr.
HK Jamu.
H.D. Jamu, Learned Counsel for the petitioner, lists this matter after 2 weeks, enabling the council to take steps for implementing the informant. The informant and the victim is the same person?
Yes.
No, my lord, this is abetment of suicide. Informing
Okay.
the father of the victim.
Okay.
My lord. Charges have been framed under 306.
Thereafter, a POSCO had come. What?
No, this is not a case.
This is abetment of.
Uh,
My lord,
enabling
small submission.
Take steps for implementing the informant in the, as a party.
My lord, the next stage date is on 21st. Can I be given some interim?
21st of
March.
List this matter again on 11/3/2020.
Meanwhile, the implement.
You bring it, we'll finish it up on that day.
My lord, implement.
If we can file the implement by 4th, I can give you on 4th.
Again, the services to go, my lord.
Service will go through the police.
My lord.
4 तारीख को लगा, 4th. You bring it on record.
My lord.
You have one tomorrow, one day. Do it.
My lord.
Diploma.
Madam, you can keep it when the matter comes up, you can just keep it. What is the citation?
Your Lordship, AIR 2021-0 AIR SC 2351.
Party?
Party name Sanjay Kumar Rai versus State of Uttar Pradesh and another.
Madhulini.
Your Lordship, here is also case of the Assam Frontier Regulation Act 1945. This is the matter of land dispute.
You are paying for?
Sole respondent, madam.
First, I may go through the fact. Thereafter, I will law, common lawfully. Your Lordship, in the
You ready?
My lord. My lord, only simple case is, this matter may be remanded back to the village authority for my lord that amicable settlement is because already.
No. Who is the first authority who decided?
My lord,
First authority who decided, Mr.
not yet decided. It is at the initial stage.
Parwana.
Parwana has been issued. Now they are contending that this is not the correct authority to decide the, my lord,
Let
the
us
issue.
go.
It has to be, my lord, referred to the village authority being.
Okay, tell me the facts.
fact of the case, Your Lordship, the land is belong to the petitioner, Your Lordship.
So fine. So who
Yeah,
raised the dispute?
Yes, and Gotupu village. And the respondent is also belong from the Gotupu village, same village, Your Lordship. Therefore, Your Lordship, in that 17/3/2016, Your Lordship, the trans highway, Your Lordship, come on the construction started from 2017 to 14 to 15. The plot is the respondent's plot. Come on this trans highway. That is why they have already taken compensation from by the respondents. And this remaining plot, this is the plot of the petitioner, Joseph. What happened after construction? During construction, as per request of the petitioner, Joseph, the trans highway, fill up fill up the soil, the particular place, the annexer, page 15, annexer 1. This is the given by the land, the trans highway, PRO. Because as per agreement, the company given the dumping the particular plot, and then there's some amount also expenditure by the petitioner. What happened thereafter? After 5 years, the respondent started for claiming the plot. The plot is belong to him. What happened? He engaged.
Now, what are you aggrieved by here?
Aggrieved here, that in 5/5/2023, one notice received from the Gangbura Association, Your Lordship. That is president. President is the old Sagali.
Page
16, Your Lordship.
Huh?
Page 16, Annexer 2. Old Sagali Subdivision Gangbura Welfare Association, Your Lordship.
Done.
Issued by the president, Your Lordship. Notice served to the petitioners. What happened is stated here. We have
So
what
what is the relief you want? You want to set aside this?
Yes, Your Lordship. Because thereafter again, what happened?
So what are the proceedings before the court?
After this notice, Your Lordship, what happened? They have visited again para 17, Your Lordship.
What is this 24?
After giving this notice, Your Lordship, they have Gangbura Association visited on 11/5/2023. That is kindly page 17. This is the photograph. What Gangbura Association tried to do against the petitioner, Your Lordship. They have come in support, and as per direction of the respondents, they have tried to demarcate without discussion, Your Lordship. Without nail, Your Lordship. Again, what happened? They have verbally warned to the petitioners. If the matter is not settled within a few days, then they have come again and they have demarcated the same place. That is why the petitioners request the application, that is page 18. This is village authority there, page 18, annex 4. This is Gangbara. This is the belong from the this Gotupu village, same village, Your Lordship. But
We will interfere with this, send it back to the Gambila. We will
Yes.
interfere with the Parwana.
yes, yes, sir. Your
Saying
last
that this association, Sagli Subdivision Gambura Welfare Association has got nothing to do.
yes, they don't know jurisdiction, Your Lordship.
We will ask the Gamburas of
Yes,
your village.
yes, Gotupu village.
Lower Gotuk village.
Gotupu village.
Why this Guy village is here?
Guy village is nearby this particular this Gotupu village. That is Gotupu village 1 and 2. That is.
No, no. Your this village has
Yes.
a village authority.
It's Gotupu village. Your.
We'll say you go back to the village authority of Gotuk village.
Yeah, yes.
Why
Yes,
is this guy here?
Guy is nearby this
No, why?
Guy
If
is
it
nearby Gotupu village. Your.
No, no. If it is Gotuk village, it will be only Gotuk village.
Yes, yes, Gotupu village. Your Lordship, as
So
per
you're
the
not getting me. You're not getting me. If you say village authority,
yes, yes,
it will be the village authority of Gotupu village.
yes.
Now, why have you in page 18 also written to Guy village? Any reason?
Now, one GB is belong from Guy village. That is why they have written. Actually, they have approached the particular village only, not Guy village. As per the order of the direction of the this honorable call, last day, may I file an application, Your
Now,
Lordship?
Gotupu is one village or Gotupu is two villages? Gotupu 1 and
Gotupu 1 and 2 is same village, and Guy is different, Your Lordship.
My lord. Admittedly, my lord, Gotupu village 1, Gotupu village 2, my lord. Two villages. And my lord, two villages, we are residing within the Gotupu 2 village. My lord, only
Both. And the land
both
in
the
dispute?
both the my lord.
Land in dispute?
Land is also within the jurisdiction of the Gotupu village 2 only. My lord. Yes, my lord, admittedly, my lord,
Yes.
the matter may be remanded back to the
No, I
village
can
authority.
remand it, but where is that?
May,
Where should I remand it back?
may I mention the para 12, Your Lordship?
Village authority.
Page 9.
Ah!
Page 9. Page 9, para 12. This is the GBs of Gotupu village. That is, there's total 5 numbers. 1 number is respondents and remaining 4. 4 there is already there, the GBs. And they are capable to settle the matter. And as per direction of this honorable court, Your Lordship, I have given the representation to cancel the local mail order. That is additional affidavit filed by me, Your Lordship.
The orders passed by this court.
Yeah, this court, Your Lordship. Third
I
para.
think the first order.
Yes. Third para clearly written here. In Gotupu village, there are sufficient GBs, that is village authority and other well-versed persons like Gram Panchayat member are present who
Okay.
are capable to settle it.
So your name?
T. Gyadi, Your Lordship.
T?
T. Gyadi.
G-Y-A-D-I.
ABI.
Madam, Chebabu. And Mr.
M. Katu.
Will you remand it?
Okay. Obliged.
Development.
Okay.
Please, your lordship. Lordship, this matter was supposed to be listed in admission column, lordship.
Fine, it's come for hearing.
Lordship, we can take it up. MLC report was called for, lordship. I think it is there.
Simple,
Simple.
but by a sharp people. All the parties are on record.
Lordship.
Madam,
Yes, Lord.
who is there for this 2 and 4?
It's a joint application, lordship.
Yes, madam, what do you say?
Yes, your lordship, I don't have any objection with regard to resettlement, your lordship. The sections are only 452 and 324, your lordship.
That's all this.
Yes.
Washing. Where is your, that settlement?
Lordship, page 44, Lord. Annexure 4.
Okay. This was.
Lordship. Much.
Only thing subject to my throat, you might have this by Monday.
All right.
Item number 28, 29.
May I, Your Lordship? Lordship, this I is being filed under section 167. As the alleged accused is already have spent 62 days in judicial custody.
NDPS.
Yes, your lordship. 60 days for 20, for commercial, it's 180 days.
180. This is normal.
Yes, your lordship, intermediate, your lordship. However, your lordship, if your lordship will just give me a day's time to verify if the charge sheet has been filed or not, because this matter, when it came on 27/2, your lordship had fixed this matter calling for CD on 7/3. So we have sent a WT message.
But madam,
Or CD.
say tomorrow you come up and tell me that the CD is been, case diary has been filed yesterday or today.
Yes, your lordship.
What would be the position? Can I then also give him a?
Yes, yes, your lordship. He has the right for default bail, your lordship.
Even if the CD is passed, fine.
Because we'll have to see if the CD has filed before the period of 60 days.
List this matter again. Where I have
Tomorrow.
that instruction. List this matter again on 4th. 4th?
Yes, sir.
Or 5th? 5th. 5/3/2024. Miss MS L. Ginny, T. Ginny, learned additional PP, shall receive instructions as to whether the case diary, charge sheet has been filed in the connected case and ipso file the date of such file.
Yes, sir. Deeply.
Just wait for a day.
Okay. Mr. Bell, item number 30. Met your lordship. This is a regular bail. They are in jail since, my lord, 1/4/2024, my lord. FIR, my lord, at page 17. It is a case of monetary transaction, my lord, on the basis of admittedly one agreement was signed.
Yes, madam. Heard Mr. A.M. Borvin, learned counsel for the petitioner, also heard Mr. M.S. T. Ginny, additional public prosecutor for the state. Issue notice. Call for the case diary in connection with Chimpu PS case number 11/2024 under section 120 bracketed P/420/409. When, madam?
On 7th, your lordship.
7th.
7th.
On 7th.
My lord, kindly
Please say.
6th, my lord, there.
She'll have to get the CD.
7, my lord, 6th kind, one day ahead. Six, only one day, my lord, I'm paying, my lord.
6. 6/3/20.
Diploma.
Item number 31.
हाँ वही तो वही गलती हुआ है. This is a typographical error, and I also did not look
I got
into
it from the official website.
No, no, it's true, but the date was 7th. Maybe while I was communicating, maybe I said second. Could hold it, right? Anyway, it's no problem. Madam Leader, the matter was listed on a mention being made. The Learning Council for the petition for
I'm for the respondent number 2.
For the respondent number 2 has drawn the attention of this court that the order dated 23/2/2024 reflects that the case is again listed on 2/3/2024. However, on the 2/3/2024 is a holiday. Full stop. It is seen that the case was originally directed to be listed on 7/3/2024. However, on account of a typographical error, the date came to be recorded as 2/3/2024. Full stop. Accordingly, list this matter again on 7/3/2024. Full stop. The respondent number 2, Learning Council for the respondent number 2, is to inform the matter to the Learning Council for the petitioner. Just inform Mr. Dubey.
Obliged.
Yes, my lord. Now, this application file, just to transfer the petition which filed before the zero session court, my lord. One matrimonial petition has been filed by the respondent, my lord, before the zero session court, my lord. But
You are the husband.
No, I'm for wife, my lord.
Wife.
Yes, my lord. But my lord, even he is not staying at zero, but they filed only to harass. My lord, come to my nature tree, my lord.
Annexure?
Annexure 3, page 16, my lord, of my transfer petition, my lord.
There is an imprimatur here?
Yes, my lord. So,
Your order is
yes, yes. Proceeding has been stated.
And you are praying for
Transfer the petition here on at UPA, my lord.
UPA.
Yes, my lord. UPA session court, my lord. Already, my lord, during the filing of this petition, my lord, the matrimonial petition, my lord, one maintenance petition pending before this UPA court, my lord.
What is that number?
That one, annexure 2, my lord, page 15 of my petition, my lord, which is disposed now, my lord.
Disposed of?
Yes, my lord, in the month of August 2023, my lord.
And the respondent has also.
Yes, my lord. But why?
Disposed of on?
In the month of August 2023. Respondent is a serviceman, man, government
Oh,
serviceman.
okay. Where are you staying? Where is your house? Here.
Here, Nahalagan, man.
And this is your matrimonial, this is your maternal house, paternal house.
Yes, my lord.
Parents?
Yes. No, my lord. I'm staying.
When you were married?
Yes, my lord.
Where were you?
We are married at Dapo and Zero also, man. And here also, Nahalagan also, my lord.
Pre-marriage?
Yes, my lord.
Pre-marriage?
Yes, my lord.
3 times he married you?
No, one time married, but we.
First resided, they married in Dapur.
Yes, my lord.
Then resided in Zero.
Zero, my lord.
And in Itanagar.
Yeah, we are staying here at Nahalagan, my lord, B sector. At Nahalagan.
After marriage.
After marriage, yes, my lord, Nahalagan, my lord.
Nahal.
And
Yes, Mr. Council. What is your?
Lordship, I have some objection here. Marriage was because Papumpare, that is UK has no territorial jurisdiction because what happened, Lordship? Marriage was performed at zero.
Where is your original house?
Zero.
Zero.
Yes. Because we are the intertribe Lordship, husband and wife.
Okay, fine. And where is
So
this
then-
present proceedings pending?
Lordship?
Zero.
Zero. Yes. Then.
And where is her house?
Her house is Upper Subunsri, Dapurija. After crossing the zero, so from Upper Subunsri to zero, it takes it's around 200 kilometers. Then from Dapo to, that is Upper Subunsri
So
to
after your marriage, where did you reside with?
Upper Subunsri.
All along?
Yeah, no, not all of them. Thereafter, I was transferred to Dibang Valley, Rohing.
She also came with you?
Yes, he also reside there.
Then-
Thereafter, again, I was transferred to now Tirap, Hunsa. Now,
So, nothing to do with Nahal.
Nahalagan. Only, Lordship, her claim is that she, in the month of March 2019, she has left my quarter and started residing in Nahalagan temporarily for 3 days. Therefore, she went back to her own permanent place, that is parental house. Now, thereafter, what happened? She has filed one maintenance case showing that she is temporarily residing at Nahalagan in the rented house. That was the claim. Then maintenance.
Any children?
No children, no. And maintenance was disposed of in the month of August.
Did you take any objection in that maintenance case?
Reg-
Regarding that contention?
Yes, Lordship.
How did the court deal with that?
But though I have raised an objection, but the court did not pass any order in that connection because they.
So, if you don't have anything here, why should we ask you?
No.
File it, we file a case for your paternal house, we'll transfer it.
Lordship, very interestingly,
My
what
lord, my
happened, Lordship?
May
Happened when the matrimonial case, that divorce petition was filed and notice was issued, and it was sent to the address given in the maintenance case, and it was returned unserved. Lordship, here I annex in page in my reply, Lordship. Kindly see page 29, annexure C. Annexure C, Lordship. This is the order passed by the learned district Judge Zero, that the learned conspirator but appearing for the petitioner is present. Petitioner took steps on the respondent and filed postal receipt, but the notice has been returned back to the court without service. Learned counsel but counsel prayed to take the press step by hand. So luckily, I have taken the press step by.
No, where did you stop that?
I have given my learned brother by hand, and in the court itself, during the trial of the maintenance case, Lord. This and second, why I have objection, Lordship. Entire witnesses who supposed to be examined in the matrimonial case, Lordship, they are from the Zero and the Porijo, not from the Papumpare.
What are you doing here?
I'm resigning here, my lord.
No, what are you doing?
Nothing, my lord.
Then?
I'm unemployed, my lord.
Then?
And my lord,
Then?
my lord, prisoner.
You have a best the case that where your paternal family is, your mother, father, wherever your house is, ask for a transfer to that place, we will grant you. He'll have to come. But this is a place where has got nothing to do. Yes. Other than that, what do you call that? Maintenance matter, fine.
Yes, maintenance already disposed
Fine,
of.
because you are residing here, then. But here the question of witnesses, everything would be there.
Yes, that is.
My lord. My witnesses are here, my lord. Staying here, my lord. At Nahalagan, my lord. Only my family.
Where is your statement?
That statement
Where is your statement? I did not find anything.
And my lord,
He has not given any such a statement, saying that this is,
and my lord, come to page 4, para 3, my lord.
You come to para 8.
Yes, my lord.
You have your parents here.
my mother is
Yes,
here,
mother.
father is already expired.
But
Mother
your
is in
parents are here.
Naharlagan.
He has a resident here, ma'am.
My original place,
Then,
He has a resident here.
then
only my mother is here.
He is not staying at zero, my lord.
I have given here the list of witnesses.
your mother here, that means you have a house here.
Yes, yes, Lord.
Then why did you not say?
But marriage was, Lordship, marriage was was done at zero, not here. As per our traditional
Para 3, my lord.
custom, Lord.
Page 4 of my petition, my lord. Para 3.
You practice here?
No, Lordship, in the Tirap, Lordship, in the, I have posted it, Tirap.
Para 3.
Next, when are you coming? We'll have to hear this.
Okay, Lord.
You cannot hear this. When are you coming next?
In Nahal, this UPI is convenient for both, my lord.
You are practicing here?
Yes, my lord.
When can you come?
Lordship, because I heard that because nowadays I didn't contact because I think most probably he has left for Manipur for further study, I think. So through government. So I
That's
will.
why, my lord, this UPI is a
Or,
convenient for
or in the month, Lordship, then, all right, in the,
zero also not convenient for her, man. His, my lord. Mother residing here.
Lordship, maybe fix on
Applicant residing here.
15 of, or 14 of this month.
14.
Yes.
Your name?
My lord,
Any problem?
T Kamchi.
T?
Kamchi.
T come.
T Kamchi.
Kamchi.
What? This matter may be disposed.
Not very convinced.
His resident is here, man.
Heard Mr. Tezi Kamji, Learned Council for the petitioner, and also heard Mr. M. Bhatt,
Yes, Lord.
Learned Council appearing for the respondent. Let's this matter again on 14/3/2024. And endeavor would be made to dispose of. The hearing.
Yes, hearing. This is
According to for final hearing. For hearing. For hearing. On that day, we will dispose.
yes, yes.
A bit.
Obliged, Lordship.
Much obliged.
We'll try.
Yes.